Section 2.10 of Topic 3, Paper 1 looks at supervision and investigations. Now, this is part of the powers of the SFC. Indeed, Parts 8 to Part 10 of the Securities and Futures Ordinance covers the powers of the SFC. And this is something that they want you to know and will be covered in a Paper 1 exam. So starting with Part 8, supervision investigation. It's a big difference between supervision and investigation. Supervision is the irregular visits that the SFC will make to intermediaries to make sure that everything is in compliance with the legislation. Investigation is different. That's where there's a possible offence being committed and they want to go in and look. Let's look at the detailed notes. So at the top page 3.9, as I've just said, there is a big difference between supervision and investigations. And the SFC has two main powers of investigation: to make inquiries, obtain documents from listed corporations, intermediaries, associate entities, and specific transactions. So they can go in and look generally at documents, or they can look at specific transactions. And then, as I've alluded, a general part to investigate possible breaches of particular legislation and activities that are not in the public interest. Now, investigation of listed corporations. Now, companies in Hong Kong that are listed on the stock exchange, the SFC has the power to go in and look at these companies and obtain records and documents and explanations and statements on oath. And the persons who may be subject to inquiry, directors, a related corporation. Now, that can be the holding company, a subsidiary, any company within a group. An AFI, that's the bank, an auditor, or any other person that is related to the company is important for the investigation. And that list has been examined in a question. Supervision of intermediaries and associated entities. So this is what I was talking about earlier. It's not as serious as an investigation. And the supervisory inspections are there to establish if the intermediary, the associates, are complying with the SFO, with the legislation. And the SFC may authorize a person to inspect premises of a licensed corporation. Now, these specific transactions that the SFC may look at, they have the power to require specified person to disclose information related to transactions. It could be something like a large options position that somebody's taken on and they want to look into it. And the specified persons can be the parties with an interest in the transaction and any intermediary involved. It's fairly wide-ranging. Failure to comply with requests for information without reasonable excuse constitutes an offence. Now, that's going to come back again and again. Anything to do with the powers of the SFC, where people don't comply with requests for information or access to information without reasonable excuse, it's an offence. You are breaking the law. Now, investigation of possible offences as opposed to listed corporations. The person under investigation is required, well, just as I've said, to comply with requests. So provide documents, meet the investigator, answer questions, give investigator all reasonable assistance, etc. If someone being investigated fails to comply with the request of an SFC investigator, then the SFC has the power to go to the courts, to a magistrate, for the issue of a warrant, which allows them, if necessary, to enter the premises by force within 7 days of receiving the warrant. So this is sort of like a dawn raid. Does this happen? Yes, it does. We don't read about it because it's all kept quiet during an investigation. But be aware that the SFC has that power. Part 9, discipline. Now, the discipline that the SFC can hand down by way of sanctions is important, and I would say you can have at least one question around this material. Now, who does the disciplinary provisions apply to? Well, we list the people there, and it's really everybody. Licensed corporations, licensed representatives, that's the individuals, responsible officers, persons involved in the management of a licensed corporation. Any person involved in the management, that is the managers in charge, and we will cover that in topic 5. And registered institutions, executive officers, and persons involved in the management of registered institutions. So you can see that the disciplinary provisions apply to both the licensed corporations and the registered institutions, as well as the individuals that are involved. Now, top of page 3.11, if a regulated person, that is any of the above that I've just gone through, is guilty of misconduct or is not fit and proper, then the SFC can hand down a number of sanctions. Before I look at the sanctions, this is guilty of misconduct, not market misconduct. Now, market misconduct, which we deal with in topic 9, is considered to be more serious because you're bringing the whole market into disrepute. Not that just misconduct is not a problem. As we will see, if you're found guilty of misconduct by the SFC or you're considered not fit and proper, then the SFC may revoke or suspend your license or registration, revoke or suspend approval as a responsible officer or executive officer, publicly or privately reprimand the person, prohibit the person from applying from any other licensing registration, and separately or in addition, they can force the person to pay a penalty up to the greater of 10 million or 3 times any profit gained or loss avoided as a result of the misconduct. Be aware of those points. They can come up in a question. Now, what is misconduct? Includes contravention of provisions of the SFO and certain parts of the new Companies Ordinance, terms and conditions of any license or registration, any act or omission related to regulated activity which is prejudicial to the public interest. Again, we've seen those points be examined. Now, the SFC may take disciplinary action in the event of, this is a bit broader with regard to the entity, the intermediary, bankruptcy, receivership, arrangement with creditors, failure to satisfy levy of execution, mental incapacity of individuals or directors, conviction of individuals, corporation or directors for an offence, which cast doubt on their fitness and properness. Now, the SFC recognises and values intermediaries' cooperation with SFC investigations. And if you comply with any investigation, you cooperate, then the SFC can reduce the sanction. You see the point there, second last major bullet point. The SFC may recognise cooperation by reducing up to 30% of the disciplinary sanctions imposed. So you get a 30% discount if you cooperate during an SFC investigation. And we list at the bottom the ways in which you can cooperate with the SFC. Be aware of those. Those can come up. Then part 10, powers of intervention and proceedings. This is even more serious. The SFC gets involved, intervenes, and stops you doing things. Now, intervention with licensed corporations. They can intervene with powers designed to protect the interests of the investors, the licensed corporation, look after the interests of investing public in general, and they're used to our licensed corporation, shown it's not fit and proper, contravene provisions of the Securities and Futures Ordinance and had its license suspended or revoked. Now, the intervention can involve notices sent to the intermediary. So it can intervene with a licensed corporation. We're isolating licensed corporations here by restricting business activities, prohibiting it from disposing or dealing with client property, requiring it to maintain property in Hong Kong so that it may meet its liabilities. So notices can be issued by the SFC to licensed corporations with those restrictions and prohibitions. Please be aware of those. I've seen those pop up in a question. SFC, continuing, may petition apply to the Court of First Instance for winding up orders, corporations, bankruptcy orders, and injunctions to prevent contravention of any rules and regulations. So you can see it gets worse as you go down the page. If a licensed corporation does not cooperate with an intervention notice, then they may receive an injunction from the court of first instance, stopping them do something. Part 11 of the ordinance relates to the Securities and Futures Appeals Tribunal, and that we dealt with in topic 1. Now, part 12 of the ordinance, investor compensation. Now, this is changed recently, so I will highlight the change in a moment. But investor compensation scheme was introduced in 2003 through the Securities and Futures Ordinance, where the Securities and Futures Commission set up the Investor Compensation Company to administer the Investor Compensation Fund. And the idea is to provide compensation to retail investors who are wronged by intermediaries with regard to trading in securities and futures. Now, investor compensation scheme was set up with 3 pieces of subsidiary legislation. The investor compensation levy rules put forward that the fund would be created through a levy on the buys and sell transactions on both the stock exchange and the futures exchange. Now, the fund filled up pretty quickly, and by 2005, they had enough money in the fund and the levy was suspended. The investor compensation claims rules says who can make claims from the fund, and what you should remember is it's retail investors only, not institutional investors. And then the investor compensation limits rules, well, these have been updated. Originally, you could claim $150,000 for securities misdemeanor and $150,000 for a futures misdemeanor. That has been changed. And now the maximum amount of compensation that can be paid per person, per claim, is 500,000 Hong Kong dollars. So please be aware of that number. If you come across 150,000, then the material you're looking at is out of date. Parts 13 and 14 relate to market misconduct. Part 13 is market misconduct under civil law. Part 14, market misconduct under criminal law. And both of those are dealt with in topic 9. 2.17 looks at part 14A of the SFO, disclosure of inside information. Now, if you trade on inside information, that is market misconduct. What we're looking at here is the other side, a listed company, which has a duty of disclosure. If an officer is aware of price-sensitive information that is not public, then there's an obligation to disclose the information to the public as soon as possible. And if you don't do that, you're breaking the law, you're committing an offense. Now, there's a major exception to this under 2.17.2, and that is where confidentiality of the information is preserved. And the one I would highlight is that information concerns an incomplete proposal or negotiation. That covers the world of takeovers and mergers. So if you are an officer of a listed corporation where you are aware that there's discussions going on of a possible merger or takeover, obviously that is price sensitive. But there's an exception to the disclosure requirement for that. And if you breach the disclosure requirement, then you will be liable. And we're told that a listed corporation and or its directors may be subject to a civil liability of a fine up to 8 million Hong Kong dollars and or other sanctions. Part 15 of the Securities and Futures Ordinance, disclosure of interests. Now, the first part of disclosure of interests is the duty of an investor to disclose when they hit a particular percentage of the share capital, and that percentage is 5%. So if I look at the top, second bullet point, 2 basic rules concerning the duty of disclosure. First, directors and chief executives are required to disclose all interests. irrespective of their percentage holding, and other persons must make disclosure once their interest in the relevant share capital reach 5%. So if you hit 5%, you must tell the exchange and the company that you are holding 5% or more of the listed company. Directors, chief executives, irrespective of their holding, they must report their interests in the listed company of which they are a director or a chief executive. We have definitions of what interests in relevant share capital are and what you have to do with a little bit more detail. 2.18.2, listed corporations' power to investigate ownership. And this has popped up in the exam. And we're told a listed company may investigate the interests held in its floating shares, including short position equity derivatives. Now, who can ask the company to investigate? Next point, a listed company must perform such an investigation if requested by members holding at least 10% of the total number of issued voting shares. It's not an individual member, although it could be if they held at least 10%, but it usually occurs where a number of members holding at least 10% ask for such an investigation. When a company investigates the ownership, it must submit the information collected to the relevant exchange and the SFC, and submit the information to the Hong Kong Monetary Authority if listed company or subsidiary is an authorised financial institution. Now, Part 16 of the Ordinance covers miscellaneous provisions, and there always seems to be one of these popping up in an exam, so I'll run through them fairly quickly. Statutory immunity is provided to persons performing the SFC's statutory functions in good faith. What does that mean? It means that if you are employed by the SFC, you're carrying out a function, your job, in good faith, and you inadvertently break the law, you're immune. You won't be prosecuted. Also, auditors of listed companies where they report suspected fraud and other improper practices, they're given immunity from civil liability. Why? Because they will have a confidentiality agreement with their client. So they're absolved of that if they are reporting suspected fraud. A person commits an offence if he knowingly or recklessly provides false or misleading information regarding a material matter to the SFC. So if you do that, you're committing an offence. Also applies to filing of public statements and disclosure obligations imposed by the listing rules. Fourthly, the SFC can intervene in civil proceedings between third parties which concern matters under the SFO or certain parts of the New Companies Ordinance. Then we're told it's an offence. You're breaking the law under the SFO committed by a company if an offence by a company is aided or abetted by an officer of the company, then that officer will be guilty of that offence. Includes senior management and managers in charge. What that's saying is you, as an officer, you cannot hide behind the company if you've helped the company commit the offence. Then we're told that powers are given to the Financial Secretary to prescribe by notice in the Gazette new financial products, including OTC derivatives. So Financial Secretary has that power to introduce new financial products. And the SFC, as we've seen earlier, is given powers to make rules, codes, and guidelines, which it does. That brings us to the end of topic 3. Topic 3 is going to have a reasonable number of questions in the exam. I would say you could be looking at 8 to 9 questions. And the best way to prepare to fill your short-term memory with all this information is to practice questions. And I refer you to our platform Examinator.online for the paper 1 practice questions.